Hello everyone. We've been receiving messages from various applicants telling us that they applied for Canadian permanent residency but were refused for some of the reasons that we're going to review in this video episode. We're going to review the most common reasons why your Canadian permanent residency application could or would be refused and what your options are afterwards. Top 5 reasons why your application for permanent residency to Canada could be refused. So uploading incorrect or incomplete documents is a very common mistake many people do. There's 3 suggestions I have. The first thing is everything is digital now. So there's literally no paper applications anymore for 99% of the Canadian immigration programs. Everything should be scanned and uploaded correctly. Even if your document is black and white, the original one, the scan should be the front and the back. And it has to be a color scan. Make sure you completely upload all the documents. Review before submitting because you do not want to submit without your complete or correct documents. Read the instruction guide. Every single Canadian immigration program and application form has specific instructions on the Canadian government website which states how to fill out the forms and exactly what they're expecting in terms of your documentation. Make sure you read those detailed instructions because these specific instructions and document checklists can and will change over time. A very common reason for permanent residency application refusals in Canada is that your job offer from the Canadian employer does not match the documents or your work experience from back home. This is a very critical point. I've seen it before with other applications. If an offer of employment comes from Canada, it's specific to a NOC code, a National Occupation Classification Code. What happens is if your previous work experience or the employment reference letter that you have provided for your work experience back home doesn't match this NOC code, IRCC may and will refuse your application. And if you've applied for a work permit and permanent residency application, they'll refuse both of it, right? So as soon as your work permit application is refused, your permanent residency may. If your permanent residency is refused first, it automatically cancels your work permit. So let's look at some examples. Let's say you're a truck driver. A truck driver typically needs some language skills. And if you don't provide the right proof of your language ability, neither English or French, they will come and refuse your application. It could be that you didn't provide proper proof of work experience. So typically we like employment reference letters which have your job description in detail, start date, end date, how many hours you've worked, and the wage, contracts, pay stubs, and insurance depending on which country you're applying from. There's a lot of reasons, and it's very vast in this job offer category that you could be refused, whether it's a permanent residency or a work permit. You have to be super careful to match your documentation to prove that you can do every single job description that's stated on the NOC code of the job offer, or at least 80%. The third reason why a Canadian permanent residency application would be refused is typically because of misrepresentation or fraud. Fraud basically means you've lied intentionally. We're not going to cover that because that's pretty much common sense. But the other point is misrepresentation. Sometimes it can be by mistake. So if you've stated information on the application form for your permanent residency or provided documents that don't represent your profile or your work experience or your personal biography or family composition correctly, that could be a reason for refusal. And the key point is that if they believe it was intentional, they will refuse you outright. If they will give you the benefit of the doubt that if there was a mistake, they may come back to you. They may give you an opportunity. You have to be careful because if you make a mistake, such as not declaring that you've previously been refused for a visa for another country, not just Canada, that is misrepresentation. And by default, it can also lead to a 5-year ban. So misrepresentation could be a variety of points that you need to be careful about in declaring in your documents and your application form. Failing to do so will lead to a refusal for your permanent residency and even for other types of temporary residencies. It's very common that many people believe that the only minimum settlement funds that are required are for express entry, but that's not the case. In 90% of all economic immigration programs and skilled immigration programs, applicants and their families need to prove minimum settlement funds to be able to become eligible and have a successful permanent residency application process. With express entry and other programs such as provincial nominee programs where you are nominated or supported or sponsored by an employer with a work permit, you still need to prove minimum settlement funds as per the program details. The IRCC federal program means that for one person in the year 2021 and early 2022, you will require $13,213 in your bank accounts in liquid funds. If you're two people, it's typically $16,449 Canadian dollars, and it just progresses onwards. So you have to be careful that even with the provincial nominee programs, even with a job offer, all these programs will require you to show minimum settlement funds according to the number of family members. And it's not the ones that are coming. Even if you have family members back home who are not accompanying you, dependents, you still need to meet the minimum settlement funds. Failing the criminality or medical check are two key criteria that may lead to permanent residency application refusals. I'm going to cover these 2 points in this one video. If you fail to give an updated police clearance certificate, that is reason for refusal. If you do have criminality, it doesn't mean you'll be refused, but you need to prove that you have been rehabilitated. So that requires separate documentation as well and specific eligibility criteria. Same with medical inadmissibility. There are specific chronic medical cases which are not exempt and therefore will lead to medical inadmissibility. Thankfully, with this government right now, HIV, hepatitis B that may be under control, these are all exempt. However, you do need to provide proper medical documentation. But if you do have specific chronic illnesses, please double check, because you, your spouse, your children, this could all lead to medical inadmissibility and a refusal. It's not just the main applicant, but it's the whole family. If you're wondering whether your case would fall under any of these situations where it could be refused, you can always book a consultation and we can verify. With medical requirements, it's more specific, so it will take time, and there's a lot of details that have to be reviewed in terms of medical inadmissibility and medical exemptions. So be careful if you're applying and you know there's some issues that you or your family members may have. A very common question many people ask is, can I reapply for my permanent residency if I was refused? Please consider 2 key factors in the answer to this. 1, you can ask for a reconsideration. And the second point is, you may reapply if there was no ban. If there was no ban, you can of course reapply under any program which you're eligible, but you do need to declare it in your next application that you were refused for permanent residency. Bad news, your permanent residency application was refused. What do you do next? Well, one option is reconsideration if you believe they have made a serious mistake or not seen one of your documents, which is rare, but it does happen. The other option is to file for judicial review or go to court, federal court, for a federal court judge to review your application if you believe there was an error in law. If you're looking at permanent residency applications, typically within 90 days, you can apply for judicial relief with a legal representative in Canada to appeal your permanent residence application. Appeal only if you believe there was an error in judgment, an error in law, or in the interpretation of the law. according to the case they've reviewed for you and they've refused. So these are the only reasons why you would appeal. It is not just for the sake of appealing, but rather trying to win an appeal is quite important. And it requires a lot of work and a lot of planning. So before you decide, you need to consult with a legal representative, is to do a judicial request for leave in order to take it to court and to fight for your application with your legal representative in order to win the case for your permanent residency. However, if you have made a mistake or your legal representative in the PR application, that is not a reason for appeal. Everything will be based in the appeal on the original application that you've submitted. So be careful, because it's a double-edged sword, this appeal process. If you need support in applying for your permanent residency application, no matter what program it's under, our team is licensed here in Canada and will be able to assist you. We speak over 8 languages and we have helped applicants from over 47 countries in their immigration plans to Canada. At Ingwe, we're all immigrants, just like myself, and we understand the challenges and frustrations in the whole immigration process. We've gone through it ourselves, so we can relate. Reach out to us and get a free assessment, and you can find a link below in the description